So the annual privacy notice, this came out in October of last year. This is kind of an interesting one because the privacy notices you had, the CFPB, they were moving towards changing the privacy notice rule. And then you had some pressure from Congress too, where they were considering making a legislative change to the privacy notice. And the idea is that sending out a paper notice every year is very antiquated with the way that consumers interact with financial institutions and other entities, and it isn't really necessary. So there's a real push from the industry to let's just get rid of these annual privacy notices and come up with something better. And the CFPB came up with something, and it's better, I suppose, but it's not as good as we had hoped, I think. So what I want to do is just go through step by step, and hopefully you can follow along and answer these questions for how it applies to your institution. So when we get to the end, it's, can you use this alternative method or not? And then we'll talk about what that alternative method is. So, as we go through these slides, if you answer, yes, move on to the next slide and get to the last one, then you can utilize this alternative method. Otherwise, you'll see you're going to be stuck using the current method. So are you eligible for the alternative method of delivering these notices? First question is, well, do you use the model privacy notice? 99% of you likely do. I'm not saying it is exactly, maybe you have some wording that's off, but do you use the Reg P model privacy notice? If you don't, then you're going to have to keep sending. You can't use this alternative method. If you do, then okay, you're one step along. Let's move on to the next slide. So second inquiry, has your notice changed since the last notice you sent, other than to eliminate categories of information that you disclose or categories of third parties to whom you disclose? So if you've changed your privacy notice in any way, other than just eliminating ways that you share information, then you're not going to be able to use this alternative method. Down the road, if it stays the same, then you can start to use it. But once you've changed it, now you're kicked over and you're just sending them the way you did before. And, the way you did before, as you all know, you can send them out via mail, you can send paper copies, and you can also send them electronically. But sending them electronically, you have to send them subject to e-sign. So you have to get that demonstrable consent through e-sign and provide the e-sign disclosures to the consumer, which is cumbersome for a lot of banks and can sometimes be difficult. So, but if you haven't had any changes, okay, then you can move on to the next slide, to the next inquiry. So now, do you share any non-public personal information with non-affiliated third parties for reasons that would trigger an opt-out? If you do, then you're going to be stuck with the current method of providing privacy notices. And when I say, do you share it in a way that triggers an opt-out, these exemptions I have listed here, those are in the rule, in the FCRA, where if you're sharing information to non-affiliated third parties for these reasons, it doesn't trigger providing an opt-out. You don't have to. So you can share for these reasons, and you're not going to have to provide an opt-out, and you'll still be okay to use the alternative method. So that'd be, providing services for the bank, processing transactions, reporting to a consumer reporting agency, credit reporting agency, as required by the Financial Rights Privacy Act when you get a request from a law enforcement agency, as part of a merger, or is otherwise required by a subpoena or other legal process. If you're sharing with a non-affiliated third party for any reason other than those, then you're out. You can't use the alternative method. If you're not, then you can move on to the next inquiry. So this is where I think it got a little complicated for me anyway. Do you include in your current privacy notice and opt out under section 603 of the FCRA. So what's that section? That's the one on the model that says, for our affiliates' everyday business purposes, information about creditworthiness. So you have, you know, 3 items in the privacy notice potentially where you're sharing with an affiliate. You know, one is, you know, for transactions. One is you're sharing information about the consumer's creditworthiness. So that triggers the FCRA. The other, just about, you know, transactions, doesn't trigger the FCRA because it doesn't pertain to creditworthiness. It's just Grand Lease Bliley. So this one about creditworthiness, and then we'll talk about the sharing with affiliates for the affiliate to market to the consumer. But so this one is on that line that says, for our affiliates' everyday business purposes, information about creditworthiness. Is that on your privacy notice? You know, have you checked yes on that? If you do, if you're sharing information about creditworthiness to affiliates, then you're out. You're not going to be able to use the alternative method. You can share with affiliates for the other reasons, or not for the other reasons, but you can share other information, but the FCRA creditworthiness information, if you're sharing that with affiliates, that's going to bump you out of the alternative method. That's a big one. That's probably the one that, as we're going through it, that's one that bumps quite a few financial institutions out of it, I think, and eliminates this as an option for quite a few. If you're not, though, I'll move on to the next slide. So the other disclosure, FCRA section 624, that's the line on the privacy notice that says, for our affiliates to market to you. Is that on your privacy notice? That one's optional. It doesn't have to be provided on the model privacy notice if you're using it. If you have it on the model privacy notice, then you have to provide the opt-out indefinitely. So if you have that on your privacy notice and somebody opts out, that opt-out operates indefinitely until they revoke it. So if it's on the privacy notice, yes, you're okay. We can move on to the next slide. If you don't have that on your privacy notice, then you reach another layer of questions. So if it's not on your privacy notice, you have the option of treating the opt-out indefinitely or treating it as an opt-out that only lasts for 5 years. If it's indefinitely, then you're good. You can move on to the next slide. Again, you're treated the same as if it was on the privacy notice. But and most people that would be providing a separate Section 624 notice would not be providing an indefinite opt-out, because the reason you do it separately is so you can limit it to 5 years. So if you've provided the separate, limited it to 5 years, now you're going to have to renew that opt-out every 5 years, and you can't use the alternative method for that renewal. So you have to keep using the standard method for that. So if you can follow all those and move on to the next slide, and as I talked about, this previous slide, sharing information about creditworthiness, is probably the hang-up for most community-based institutions, because generally people, this is on the privacy notice. I haven't seen many forms where institutions are using this separately and doing the 5-year rollover, particularly smaller institutions. But assuming you've met all these, then you can move on to the next slide. Congratulations, right? You can use the alternative method for providing the annual privacy notice. Okay, but despite cooling the gang, what does that even mean, right? Now, okay, you can use this alternative method, but what is it? You had to jump through all those hoops, and what do you actually get? What does it entail? So this is how you go through the alternative method. 1, annually, you have to provide a clear and conspicuous statement on some notice that is sent to the consumer. Probably would be in account statement, coupon book, some annual notice that is sent to the borrower you'd provide this model statement. Federal law requires us to collect and share information. Our private policy hasn't changed. You can look at it here. If you go here, we'll mail you a free copy upon request. That's the language you'd use. You'd put that on your periodic statements, most likely. You also have to have your privacy notice out on your website, posted in a clear and conspicuous manner on a standalone page. So it has to be, the way that a lot of people do it now would work, where you have a link to the privacy policy on the bottom of your home page. You click on it, and it opens up a standalone page that has your privacy policy. I think it's reasonable. I haven't seen an interpretation on this, but I think it'd be relatively safe to click on it and have it open a PDF of your privacy notice. I think that'd be okay too. If you can't embed it, a lot of times putting it on a website messes up all the formatting. I'd rather have the formatting and content as close to the model as possible and have it on a PDF than having to put it within a web page and get everything mixed up. So you have to put it on a standalone website. It can't be behind a login, so it can't be something that's only available after you log into online banking. It can't be something that's only available after you do a click wrap agreement where you say, I agree to your terms and conditions. It just has to be on your a page that's available publicly that people can get to. And the third thing you have to do is to go back. If someone, under this language that you include on your statement, requests a copy, you have to mail them a copy within 10 days. And if you do those three things, then that's all you have to do going forward. So I think the end result, the alternative method to me is reasonable. It's posting it online, which most institutions were doing already, including a statement once a year that's relatively short. That should be pretty easy to put in a dialog box on a statement. And, if someone, in the unlikely event someone requests a copy, you send it to them. I mean, that all is I think, relatively reasonable. Where I kind of depart from the CFPB's rationale is all the hoops we had to jump through to be able to get to Cool and the Gang and the congratulations page. All the various, do you provide this opt-out, do you not provide this opt-out, all of that I think is very convoluted and eliminates a lot of institutions from even being able to take advantage of this rule.